What is an alteration agreement? We'll demystify this topic in the following video. In case you're not familiar, my name is Chris at Hauseit. Hauseit is the largest for sale by owner and buyer agent commission rebate company in New York City, established in 2014. If you have any questions about buying and selling and how you can save money on broker commissions as well as closing costs, please check us out, www.hauseit.com. The spelling is below. We do come out with content on a regular basis, so if you like what you see, leave us a comment, hit like, subscribe, and we'll make sure to get back to you as soon as possible. Now let's begin. So, you own an apartment, a co-op or a condo apartment in New York City, and you think it's yours. So why not make a few changes? You put up new cabinets, you perhaps put in a washer dryer, or you want to put in some new windows. Why don't you just go ahead and do it? Especially if you're in a condominium where there are granted less rules and you are a real property owner and you do own the interior of your apartment at least. What's wrong with that? Well, we've seen this in person in real life examples with many people. For example, just changing the windows in a condominium unit is not allowed. In fact, any changes, additions of equipment, or alterations to an apartment are not allowed even if you are in a condominium unit, not to mention a co-op apartment. In fact, the bylaws of condos and co-ops require any additions or alterations to the apartment itself, even in the interior, to be approved and consented to by the condominium or co-op corporation. In simple English, this means you need the approval of your condo or co-op board before doing any renovations or changes to your apartment, regardless of whether you live in a co-op apartment or a condo apartment. If you are an owner, it does not matter. And we definitely don't recommend testing the limits of patience of your condo or co-op board. If you try to do this in an underhanded manner and secretly hoping that they won't ignore, well, it's very likely that the super or someone else in the building will eventually figure out that you did do some renovations or changes. And when that happens, if you don't have an alteration agreement signed and if it wasn't properly approved, well, they could easily make you undo all of those changes. For example, in the window example we gave, let's say a hypothetical condo owner decides to spend $8,000 and change his or her windows. Well, the condominium board, when they find out, will actually make this condo owner swap out and throw away all of the windows and then do an alteration agreement, go through the normal procedures, install new windows for another $8,000. And plus, don't forget all the fees associated with an alteration agreement, which we'll discuss shortly. And what reason might a condo board give for changing windows that are exactly the same? Well, in one real life example we've seen, a condo board decided that the original windows, besides not having been approved in the first place, were a slightly different material, even though the building itself was not landmarked, meaning that there was no city regulation for what the exterior might look like. So even though in this particular case, the windows looked identical, but they were of a slightly different material, granted aluminum versus wood, but the color being the same, and from the outside, any differences being imperceptible, well, once the board found out, the windows were required to be discarded, given away for free, and then the condominium unit owner was required to go through the same process, pay all the applicable fees and get all the applicable sign-offs, and then pay for new windows as well. So all in, double the cost. Please don't make this mistake. So what's included in a typical alteration agreement? Well, it's a rather lengthy legal document between the condominium or co-op corporation, essentially the corporation that is run by the condo or co-op board of directors on behalf of all the unit owners. It's an agreement between this corporation and the individual unit owner of a condo or a shareholder of a co-op corporation. This agreement, for example, will state what fees are required as a part of the alteration process. There usually will be a non-refundable alteration agreement fee that's paid to the building. There will also usually be a refundable escrow deposit to pay for any damages that might occur. There will also be fees required to pay for the building's engineer to inspect the plans beforehand and to sign off on the renovations once complete. A typical alteration agreement will also have rules around maximum completion time, for example, 6 months. So this prevents a situation where a unit owner drags on renovations and is indecisive for months and months and potentially even years, and makes the lives of all other residents in the building miserable. And to prevent this, an alteration agreement will also have per diem fees post the expiration period. For example, if the maximum completion time is 6 months, any additional days over that time limit will be charged a per diem fee of eventually as high as $1,000 a day if the renovations are ongoing. A good alteration agreement will also have limits on what hours and days of the week that alterations are permitted. For example, no weekends are quite common, or 9 a.m. to 5 p.m. on Monday through Friday. Of course, any alteration agreement will have a myriad of other requirements on such things as safety, procedures, insurance that contractors must have, proof of licensure, and much, much more. We hope you found this video helpful. You can learn more about how to save money on broker commissions and closing costs at www.hauseit.com. Again, please hit subscribe if you like what you see. We do come out with content on a regular basis, and we welcome new topic suggestions.